Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey guys, so this one is an update. I don't know if you guys remember, but y'all remember Corey SSG's ex-girlfriend Danny. Her real name is Chestine Washington. Well, she ended up suing Sherrell Hodge. And if y'all don't know who Sherrell Hodge is, Sherrell Hodge has been coming up in quite a few things. She was the one who was helping out the lady where what's that food critic Keith Lee, I believe, when they came out here to Texas and the lady had the food truck and he gave them money and the lady didn't end up paying Sherelle and all them. So that's Sherelle. You also know Sherelle and the Ashley Grayson, where Ashley Grayson tried to unalive Sherelle. So it was some crazy stuff. But Danny, aka Chestine Washington, ended up suing Sherelle for defamation and harassment. So if you did not see that video, I'm going to tag it at the end of this video so y'all can get caught up. But I do have a court update, and this is a special request for an individual who inboxed me and asked me to explain some things. So I was like, let me just go ahead and do a court update because I haven't done an update in a minute. So pretty much in the video, Sherelle was just kind of giving everybody an update as far as what was going on with the case, and she did mention that they had what is called they. She stated meetings, but what it's called it is a deposition. And a deposition is where you have the plaintiff counsel and or you have both counsels usually depose the opposite party. So the plaintiff's attorney will depose the defendant and the defendant's attorney will depose the plaintiff. Now, Sherelle is pro se, so she had the opportunity to depose Chestine, and there was some things that weren't answered, or she refused to answer, or she lied about. So Sherelle was like, you know what? Since you want to sit here and lie about stuff, let me go ahead and issue out some subpoenas. So she had, and I'll show you guys all that, but I'm jumping ahead. But this is the court docket. So this was filed on September the 3rd, 2024. Initially, Chestine was the plaintiff and Sherelle was the defendant. Sherelle ended up answering around the 10th of, I'm sorry, not the 10th. Let me go back. So she answered, so it was filed September 3rd. And she also put out Danny also put out a restraining order. She's like, "Look, don't you come near me nor my businesses," because she was talking about Sherelle was popping up at the businesses and everything. Y'all gotta go check out that video. Um, and so let me see. So then Sherelle ended up answering November 11th. Not only did she answer, but she also filed a counterclaim. And baby, she was talking about how Chastine was sitting here putting pictures of her out on on her page and all. Man, y'all, it was bad. It was bad. So fast forward to this month, an amended petition was filed on the 7th, and I am going to go into that amended petition. Chastine ended up what actually Chastine filed the amended petition. Sherelle ended up answering, and then she also ended up filing a motion. But in between that time, I am assuming that sometime between October and January, they had depositions. And whatever happened in depositions obviously did not go the way that it was supposed to. And so Sherelle said, okay, I am going to end up, since you want to lie about some Facebook posts, then what we're going to do is we're going to subpoena Facebook and they're going to tell us exactly. That's why I tell y'all, she said this in her video. I always tell y'all, even though y'all may think that when you delete it or y'all deactivate it or whatever the case may be, you think that you're doing, it's somewhere. It is stored somewhere. And so this is probably the best, smartest thing that Sherelle did, because I'm assuming that Chastine lied about saying She created a Facebook page and started posting all of this stuff, and then tried to delete it. And Sherrell was like, I know how to get you. So Sherrell is very smart, very, very smart. So as y'all can see, she requested the subpoenas on the 10th, and then this was this was actually very, very fast, because it said on the 11th the green card service return was sent by certified mail. Okay, so it was sent by certified mail from the court to Meta. So Facebook, Instagram, WhatsApp, all of them would be subpoenaed if there's any information related to uh what she's trying to get. And actually, I do have that, and I'm gonna read this because it is kind of small. So Sherell submitted this to Meta platforms, and this is what she stated. She wants them to testify or provide documentation on behalf of her, because she is the defendant in this case. And she stated that she held depositions with opposing party refused to answer truthfully or answer at all. I am requesting posts, messages, and stories from defendant's account from January 2024 to January 2025 that pertain to myself, Sherrell Hodges, for the relevancy in this case. Excellent. I love it. I freaking love it. All right, so let's get into the amended complaint right quick. All right, so let me get that. All right, so this is the amended First Amendment complaint that Chustine, aka Danni, ended up filing. So we kind of got a gist of what happened, but let me see. All right. So, conditions precedent. Plaintiff has made the proper request of defendant for correction, clarification, or retraction pursuant to Texas Civil Practice and Remedies Codes. Because remember, she asked the court to have a temporary restraining order against Sherell, saying that Sherell can't be nowhere near her businesses, so on and so forth. So, what she did is she submitted an amended complaint, but she's saying that all of this should still apply. Even if we amended the complaint, it still should comply. So, specifically on September 3rd, 2024, the court granted plaintiff a temporary restraining order, ordering the defendant for no more than 14 days from the date of the order not to intentionally communicate with the plaintiff in any way, as vulgar, profane, or supposed to say use vulgar, profane, obscene, or indecent language, or a course of an offensive manner with intent to alarm or annoy plaintiff, threaten the plaintiff in person, by telephone, or in writing, or to take unlawful action against any persons. Place phone calls to plaintiff anonymously at any reasonable hour in an offensive and a repetitious manner, or without a legitimate purpose of communication, intentionally knowing or recklessly causing bodily harm to plaintiff, threatening plaintiff with imminent bodily injury, intentionally or knowingly damaging, destroying, or tampering with the property of the plaintiff, enter a store owned by the plaintiff, post videos stating that the defendant will harm the plaintiff, and defame the character of the plaintiff. As the defendant's behavior did not change, in spite of order, plaintiff sent a cease and desist letter to the defendant on October 28th, 2024, demanding that the defendant correct her actions and retract any false statements. Especially the letter noted that the defendant continued to harass and intimidate the plaintiff by actions, included but not limited to posting negative and false comments on various social media sites, and directly contacted business partners or potential business partners of my client for the sole purposes of attempting to terminate or prevent her ability to contract and do business with a number of third parties. The defendant was also informed in that letter that there was no reason for her to communicate with plaintiff for any reason or state anything about plaintiff to third parties, which is false, malicious, harassing, intimidating, and done for the purpose of harming the plaintiff both personally and professionally. The letter also stated that the defendant must cease and desist from the aforementioned activities immediately. All right, so what has happened now? Plaintiff Chestine Washington is a self made businesswoman who runs a number of successful businesses in various industries. One of the businesses she owns is a franchise store of the Peach Cobbler Factory in Collin County, Texas. Plaintiff also owns and runs a successful tax businesses in numerous locations. Defendant Sherrell Hodge, according to her website, is among other things a social media influencer based in Texas. Neither defendant nor plaintiff knew the other personally before February of 2024. For reasons unknown, beginning the February of 2024 and continuing to the present day, Sherrell Hodge decided to pursue a vicious and unprovoked barrage of attacks against the plaintiff's businesses and character as described herein. Specifically, defendant intentionally, repeatedly, and widely and maliciously decimated her deliberate and defamatory falsehoods through publicly released messages on Facebook, Instagram, YouTube, TikTok, and other social media outlets. Defendant intended and continues to intend that her malicious and baseless defamatory statements publicly humiliated plaintiff and discouraged others from utilizing her various businesses. As noted above, plaintiff has demanded that defendant retract her defamatory statements and cease and desist her from hurling further defamatory falsehoods against plaintiff. However, to date, the defendant has refused to do so. Intentional, unprovoked confrontations by defendant. As stated in her original petition filed with this court, on two separate incidents, defendant Sherell showed up to plaintiff's PCF and threatened and harassed, and this is the Peach Cobbler Factory, threatened and harassed both the plaintiff and the employees. Moreover, plaintiff began posting negative and harassing comments about plaintiff on social media. Oh Lord, they got the exhibits to go with it. Post other order incidents. Incredulously, on the same day, the court issued the TRO, the temporary restraining order, and into and beyond the 2-week protection period therein, defendant continued her barrage of defamatory, malicious, and libelous attacks against the plaintiff. The following posts on social media sites available to the public. So it states that posting defendant by defaming and falsely and maliciously accusing plaintiff of stealing a person's identity. On September 3rd and the 5th, she said defaming and disparaging plaintiff by implying she registered her car in someone else's name and stating the war has begun. Let's see. Defendant posted on September 5th, falsely and maliciously implying defendant is a bad mother. What else she posts? She stated that plaintiff is committing fraud by cashing clients' checks. She also stated that plaintiff was printing checks in a fraudulent manner, that plaintiff is stealing clients' tax return funds. Plaintiff was not operating a legitimate tax business, and that plaintiff defrauded an individual into paying her security services invoice. A video that was posted by Sherell on September 2024 admitting she confronted plaintiff falsely and maliciously, accusing her of criminal activity, revealing information that was stated at court, admitting she had knowledge of the TRO, and implying that she was going to violate the TRO. Oh, Lord. Videos posted by defendant on September 12, 2024, disparaging and defaming plaintiff, playing audio tape that defendant made while court was in session, and specifically violating the TRO by disparaging and defaming both the plaintiff and her business. I wonder, can I get, let's see. Ooh, okay, hold up. Oh, man. Do I think that this is a good idea? Probably not. Cause child, what? Hold on, I'm about to share my screen. Let's go back.
Restraining order is granted. Now let's see who got their bag for their attorney. Mine is hired for my defamation of character case. This is the first I ever just pushed an issue, but somebody got to be an example because there's too many people who want to be investigators. And Vaughn, I'll see you in court last week of this month because not only did you lie like I got a car in your name, you lied like I got a loan in your name. And the whole time the paper was for Safe Home Security Services account that you had to get as an investor of my tax company back in 2019, 2020. Danny, no, that is not what he said. Hold on, because now I gotta play this part of the clip. Hold on. Listen to this.
I only have a request to prohibit any harassing, annoying, alarming, tormenting, or embarrassing information. What I take it is posting anything on the internet, on any of the social media outlets, or going to the place of business.
Boom. One more time. What'd he say?
That's granted.
He said, only thing I'm going to grant is her going to the place of business. That's granted. He didn't say nothing about the internet thing. If that was the case, then what the fuck is you posting on the internet for? Huh? Do we need to listen to it one more time?
Any harassing, annoying, alarming.
Hold on.
They can do, but this is not one of them. Now, I don't have before me a request running both ways. I only have a request to prohibit any harassing, annoying, alarming, tormenting, or embarrassing information. What I take it is posting anything on the internet, on any of the social media outlets, or going to the place of business. That's granted.
Did you hear what he said? He said, I don't have before me any order besides posting anything embarrassing on the internet or going to the place of her establishment, employment, whatever the case is. And he granted it. Whoop-de-doo. You got a judge to say I can't go to the peach cobbler factory. Nobody gives a fuck. The shit is nasty any fucking ways. He did not silence me. He did not say I couldn't talk about it. He did not say I could not use my First Amendment right to speak on it. So if you're going to utilize it and what the judge said, utilize it right, Danny. So yes, I'm so glad you got your defamation attorney because I'm excited. I'm about to bust your life wide open. I promise.
Okay. So I don't know why they put that in there because that is like not at all like the judge. We heard what the judge said. So he didn't have an order in front of him just saying that she wouldn't be able to say her name on the internet. He just said she can't post anything embarrassing and she's not allowed to go to the peach cobbler factory. Okay. Let me pull up the second one. Hold up. Let me share it. All right, let's get into this one.
Well, there y'all have it. Motion for temporary restraining order to be submitted. No posting to social media and no entering the place of her business. Meaning, I could talk about her all the fuck I want to. All the fuck I want to. I cannot go to the peach cobbler factory. Yeah, because no judge is going to sit there and say, if she's posting about something you allegedly did, how? Y'all see it? Y'all see it?
Okay. So it said no posting on social media. So I think that will also cover the fact that you can't say anything about her on social media, or because normally anytime we file lawsuits, especially when you're dealing with defamation, we always advise clients not to even get on their social media, period. Not even for a case update. So interesting. Videos posted by the defendant on January 20th, maliciously disparaging and defaming plaintiff, calling her a liar, a jackass, and implying she's a bad mother. All right, I'm not going to click that link. Y'all could definitely go and see that. Post cease and desist incidents. Video posted by the defendant approximately November 2024. Let me see what she says. Threatening to physically harm and bully the plaintiff. All right. Let me. Child, what? Hold on. Yeah, because we gotta, I have to get y'all into, we understand what's going on. So give me a second. All right. Run that back. All right.
Expose this person, that person, da 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 da. All right, so I started getting messages about this Danni chick. Now keep in, I didn't have no beef with the bitch at all. But because of what it was that I was doing in the platform that I had, shit, I'm gonna be the voice for the people. So I started posting the shit. This bitch took it. Of course, she should have taken it personal. I'm hitting you in your pockets. But this bitch decided, instead of, doing what most people do and just start blocking people, she decided to get outside her body and start everything. Posting pictures about me, calling me a mustard, like a little mole rat. She started telling people to call CPS, like weird ass shit. And then my only issue only arose when the CPS shit. I was fine with the jokes, bitch. You can call me bald headed. You can call me bald headed all damn day. That shit don't bother me at all, bitch. I wake up to me every day. I know I'm bald headed. You reminding me every day is just a second reminder, because I remind myself every day I wake up and have to put my wig on. I don't even have to. But you know what I'm saying? But when she got to the point where you want to start getting random people to start making CPS reports, now I got to start dealing with CPS and da da da. Like, nah. Now, bitch, you playing. Now you playing, and now I'm ready to box. Now I'm ready to box. Now I'm ready to see about that. I want to check your temperature. Money or not, I could be the brokest motherfucker in the planet. But, bitch, when I see you, you gonna think I'm the richest. I promise. Because you gonna be like, how did you find me? Bitch, I gotta see you. Dallas ain't that big. You better take your ass back to Timbuktu, Mississippi. Because that's the only way you'll never run across me. And I'm standing on that. I'm standing on that. Feel how you want to feel. Oh my God, we love Big Danni. Yep.
Child, it is the
I love her
internet
too.
connection for
I
me. Or it's her
love her with
connection.
the love of the Lord, but I'm going to tear that ass up when I see her. I promise. And this is not a threat. This this is a friendly, casual something. I don't know. But yo, nah, bitch, you not finna sit there and then you want to keep hiding behind these motherfuckers gas you on the internet. You want to keep hiding behind all of this clout and shit, bitch. Keep it a bean, bitch. You ain't living like that. You not cut like that. You not, no ma'am, no ma'am. And honestly, I'm not even living like that. Let's just keep it a bean. I'm not the type of bitch that's gonna get out here, oh, I'm just gonna fight for everything. Da 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 da. You know what I'm saying? Nah. Me personally, I'd rather use my words and then just do some slick shit on the back end and get all your shit just towed down. I'm the type of motherfucker that'll get behind my computer and get all this shit towed down. Fuck that. I don't got no energy to get behind a computer. I got energy to get in the field. And behind this, I'm gonna stand on it. I'm cut like that today. Let's just put it like that. I'm cut like that today. Bitch, hold on. Today, tomorrow, and whatever other day that I need to be until I touch you. That's it. That's it. I just want to get with you, pray with you, sing a little gospel hymn, and then go on by my business. Yeah. I'm not a bully until I have to be a bully. And bitch, I'm going to bully the fuck out of you.
Okay. Yeah, so that one was a little bit interesting because at first she said, I can't wait to touch it. Then she said she gonna pray for her. So I don't know. All right, so going on says posting by defendant on January 6th, threatening to embarrass, defame, and disparage plaintiff on social media. There's a video posted on by defendant on January 6th, falsely and maliciously accusing plaintiff of criminal activity and implying she is or will be under investigation by the United States Internal Revenue Service. Oh, this is interesting. Hold on, because I want to see this because I know that CoreySSG, was mentioning uh something about Danny. Don't y'all remember that? It was something about he was holding some papers up in his car before he went to jail, and he was saying that Danny was out here frauding man, just doing us some crazy stuff. So I don't know if Sherell is getting this information from Corey or what, but let's tap into this one.
Other where I talk a lot of shit, and today we talking about motherfucking dead. Now, a lot of y'all ain't been to Sherell's closet. Someone got it together. Yes, I know I need to take them all the way up to the crease so they'll hang a little better. I'll do that tomorrow. But y'all, why the fuck is Danny out here being shady to other professionals? One specifically being like my sister, my best friend, my ride or die type shit. Talking about, let me just show y'all. This motherfucker said if you filed with Whitney Phillips, y'all already know I put Whitney on everything: credit, taxes, motherfucking pallet flipping, all of that, right? If you file with Whitney Phillips or any of these tax hoes that don't like Danny, call the IRS after your return get acknowledged and tell them that you're not familiar with the bank account that's listed on your 1040, and they will send you your whole refund and add the prep fees back into the refund. I'll start a tax drought. You're going to regret that live. Do you know how many motherfucking people finna be in a courtroom getting their ass sued? And let's not even get to the sued part. Let's get to the criminal act when you called and made a false report to the Internal Revenue Service. Now listen, y'all. These companies, these tax companies have been in business. And specifically Whitney, she has been in business for a very long time. I'm talking about a top tier A1 relationship with the motherfucking IRS. Like she call them, she ain't even gotta wait and go through the prompt. She gets straight through type shit. So when a company knows that a tax company has been successfully, properly, 100% integral, been filing taxes every year, and then all of a sudden a motherfucker want to call the IRS and report that they don't recognize this business? You got to know the IRS is launching an immediate investigation, and not into the tax company. See, it be dumbass shit like this that bitches be saying, and they just do not know how this shit could fall back on it. Imagine getting sued. Imagine doing this dumbass shit, ending up in court, having to pay for pain and suffering, having to pay for defamation because you called and lied, and so forth and so more. And they can ask for whatever they want. Don't sit there and let no motherfucking $2,500 tax return that you only got to pay a person $400 out of because they had to scribble, scrabble, and read through clear motherfucking paper to get your ass to return. Don't sit there and let that shit have you owing more than whatever your filing fee was. Okay? But anyways, this was episode 3 from Sherell's Closet, and
It's a lot. It's a lot at this point. Like what? So what Danny has done is she has posted every TikTok and YouTube video that Sherell has made, that she is claiming that she pretty much is lying or she is threatening her, which is a violation of the temporary restraining order. That's what she's alleging. Um I don't know how to feel about this because when Sherell did post that the TRO was granted, I need to go. I should have got that. I need to pull that and see exactly what it is that the judge granted. But um, the TRO did say no posts in the social media or and not or but and Sherell cannot go to the peach cobbler factory. So what all constitutes in regards to the actions that she can't do? Like, are you saying that she can't post, period? Or she can post, but she can't, speak on Danny? That is the gray area that I am wondering. But let's go ahead and continue. So it goes on to read that postings by defendant on January 6th, 2025, disparaging and defaming plaintiff and her tax business by falsely and maliciously claiming plaintiff's business posts are lies and threatening to harm plaintiff's tax business by threatening to file false information with the IRS and publishing plaintiff's confidential business information. So, once again, they're suing for defamation, libel, and slander, and we already know why. Because, when you do that, that not only hurts the person, but that also hurts their businesses. Peach cobbler factory businesses, tax businesses, all of that, especially if you don't have any proof that tangible proof that it's the truth. All right. Business disparagement. Defendant published disparaging words about plaintiff's economic interests that were false, including but not limited to those statements enumerated above. The statements were published by the defendant with malice and without privilege. Defendant's publication of the statements caused special damages, including loss of sales, loss of enterprise value, loss of business, lost profits, and loss of asset value. Plaintiff seeks those special damages, her expenses of counteracting the publications, exemplary damages, prejudgment interest, post-judgment interest, and court costs. She also talking about the civil harassment. The defendant conduct was directed at the plaintiff and was reasonably likely to harass, annoy, alarm, abuse, torment, and embarrass her. The defendant reasonably fears and still fears for her safety. So she is asking to be entitled to nominal, general, actual, and special damages resulting from defendant's defamation, including compensation of injury to plaintiff's reputation. She's asking that she be entitled to special and consequential damages, including specifically to the pecuniary loss suffered because of defendant's defamation. She seeks to recover punitive and exemplary damages against the defendant, which constitutes malice as described in Chapter 41 of the Texas Civil Practice and Remedies Code. Further, defendant acted with a specific intent to cause injury to the plaintiff or conscious indifference to the rights, safety, or welfare of the plaintiff with actual subjective awareness that her conduct involved an extreme degree of risk of harm to plaintiff. Plaintiff also seeks punitive and exemplary damages in order to punish and deter the outrageous conduct taken in heedless and reckless disregard for the plaintiff's reputation and as a result of defendant's conscious indifference in destroying her reputation. Whew, boy, they are going at it. The girls are going at it. All right, so this is the temporary restraining order, which was signed by the judge. Okay. So here is the thing. When you file a motion or a request, you have to put a proposed order. And that proposed order has to outline everything that you are wanting. So if she did not want her to post on social media, then she would have says, okay, no posting on social media, no saying my name on social media. You have to be very specific because if the judge look at the order and they deny it or they grant it, whatever's denied or grant, whatever's on there, that's what's being denied, or whatever on there is being granted. Sometimes the judge can't add additional things that they feel is necessary. So the only thing that they put, this is the ex parte, this is the 2-week restraining order. Plaintiff has filed a petition signed under penalty of perjury in which Chastine Washington is the plaintiff and Sherrell Hodge is the defendant, seeking a temporary and permanent injunction and requesting issuance of a temporary restraining order, restraining defendant to stay away from me. That's all she said. She can't communicate with her by telephone, writing. She can't use vulgar, profane, obscene, indecent language or in an offensive manner. She can't threaten her by telephone, writing. Well, it says right here, threatening, in person, by telephone, or in writing. Didn't say anything about social media. Placing one or more phone calls, cause any bodily harm, intimate bodily harm, can't threaten her, cannot damage, destroy, tamper, tangible property. Let's see. Threats. Walking into my store and posting videos on YouTube saying she is going to harm me. Defamation of character. That's all she said. So it's not detailed. So we have to think about what is on this order. All she said is posting videos on YouTube. She didn't say anything else about social media. She didn't say anything about TikTok. She didn't say anything about Instagram stories. She said YouTube. So you have to be detailed in these things. Interesting. What is this? Oh, this is the cease and desist letter that was sent back on October 28th, 2024. Let's see. It reads that it has come to my attention that you are continuing to threaten, harass, and intimidate my client by your actions, including but not limited to posting negative and false comments on various social media sites. Equally rigorous to the above, upon information and belief, you directly contacted business partners or potential business partners of my client for the sole purposes of attempting to terminate or prevent her ability to contract and do business with a number of third parties. Such conduct can potentially be considered tortious and inference with business and is actionable in the state of Texas. If in fact, if this in fact occurring, you must cease and desist from the activity immediately. Hmm. Any further such conduct may refer in a further injunctive relief against you. As previously discussed, this is no reason for you to communicate with Ms. Washington for any reason or state anything about Ms. Washington to third parties, which is false, malicious, harassing, intimidating, and done for the purpose of harming my client both personally and professionally. In addition to the litigation she has filed to date, based on your actions, my client is contemplating all additional legal actions she would be allowed to pursue, including but not limited to seeking injunctive relief. Oh, man. So they're just saying, hey, you are in a lawsuit right now. So any communication needs to be directed to the attorney. Any evidence she has must be preserved. Because if she doesn't preserve it, then that's jail time, possibly. Let's see. See, that was the petition for the injunction. We went over that previously, so we don't need to go see that. We don't need to see that. That's the P. Okay. So I'm assuming that's her. I still feel the same way. Trash. Oh, Lord. Yo, y'all gotta share this. I'm gonna hand deliver this MF to the folks, I promise. Only way I come up off of her, she gonna have to drop a bag. Danny stole this man's identity. Child, what? Lord. She's stalking the girl page. I'm crying. She said, hey, somebody asked Danny who named that RR in and why is it registered in Virginia? A Rolls Royce. You have no relations unless you got that car in somebody else's name, just like you did, old boy. The war has begun. Baby. She's so smart. Video proof of her walking into the dealership, putting the car in someone else's name? Oh Lord. Why Danny mama saw all that BS that she was doing yesterday, told her to come get her kids, and Danny's response was, I'm not about to stop loving my life to come get them. Call they daddy. Girl, go be a MF for mama. Y'all can ride tricycles together. Child, what? Hold up, what this say? Let's not forget on 2K Live, she said goes wait, she said she goes and cashed her checks for the client sometimes because she's the owner. Why would that even need to happen? If they filed the taxes, they should have an ID to go cash their own checks. I don't know, allegedly. And then she had a picture of her, what is that, refund transfer application information. Baby, this is wild. Oh gosh, let me see. Too much tea. You swore under oath that your company didn't print checks. According to the return you filed with your bank, you did. Ooh, cha. this is good on Chustine's part, putting all this stuff on there. All that. This is the tax. This is the bank I was seeing on all them people tax returns with the account number that ends. Ooh, I think I've just figured out where all the money going to. Oh Lord, Jesus. All right, let's see. And then she says, remember, do not let anybody file your taxes if they don't have a legit up and running business. Dissolve. It no longer exists as a legal entity and cannot conduct business or enter into contracts. IRS, yes, hello. There's a tax business running and they aren't allowed to. Here come the new tax name. Good grief, this is crazy. These supposed to be Vaughn security system accounts, correct? Why is another grown man information on these accounts? Then on a couple accounts, it's just Janny and Jarvis listed. Why didn't the contracts be signed and sent back from Vaughn's email if they were in his security accounts? If your lawyers told you anything, it should have been to keep your mouth closed. You just get deeper and deeper. Sit back, Vaughn. I'ma hand deliver your case to you in just a couple of days, I promise. She's given up everything you need. The crazy part is I don't know if this was a good idea for the attorney to even post this. It's like you implementing her. Hold on, let me see what this is. I can't take this woman serious. Oh, this is her tax business. Oh my gosh. I'm sorry, because I have to blow up these pages. Then I gotta. That's just showing the tax page, and that's just showing her tax business. Oh my gosh. So Sherrell answers. So that was just the amended complaint that I read. Okay. So in a nutshell, Danny is saying Sherell's not following the temporary restraining order. She's still harassing me. She's threatened me. She's still contacting my businesses and this ain't right. This ain't right. So since she is doing this, it is causing me reputational harm, it's hurting my business. I deserve damages. So Sherelle reads it and then she goes ahead and she files her answer to Sherelle's, not Sherelle's, Chustine's or Danny's amended petition. And she just pretty much, girl, oh, but I, this girl reads. One thing she does is she reads. She states that plaintiff failed to obtain a permanent temporary restraining order. Plaintiff claims she was in fear for her life but failed to follow the court's instructions to extend the temporary restraining order. If plaintiff was truly in fear, she would have pursued a permanent order, which she did not. Defendant never violated any valid temporary restraining order as no permanent order was granted. Technically, a permanent order won't be granted until after the lawsuit has concluded. So that's number one. So they can file temporary restraining orders until the case concludes, but they have to make sure before it concludes that they strive to have a permanent temporary order in place. Plaintiff owns conduct contradicts her claims of fear. Despite claiming to fear defendant, plaintiff sat next to defendant in the courthouse lobby and engaged in direct conversation. After the TRO hearing, plaintiff called defendant's phone multiple times and participated in a YouTube video with defendant, laughing and conversing. These actions are inconsistent with someone who is generally in fear. Girl, what? Defendant did not threaten plaintiff with bodily harm. The court itself stated that there was no evidence of any bodily harm threat during the original TRO hearing. Plaintiff claims that defendant threatened her is completely false and was not upheld by the judge. Plaintiff mischaracterizes social media posts as defamation. Plaintiff is attempting to silence defendant's First Amendment rights by framing opinion based statements in public records as defamation. Defendant never asserted as fact that plaintiff engaged in illegal activities. Instead, defendant shared an already existing post from Vontrarius Funches, who alleged alleged plaintiff used his identity. Lord, posed a question regarding the registration of a Rolls Royce rather than making an assertion of fact. Shared public business records indicating that plaintiff's businesses were dissolved, which is factual information. Oh, she eating her up. Posted a general warning advising individuals not to file taxes with someone who does not have an active registered business. Defendant cannot be held liable for third party statements. Plaintiff's defamation claims are invalid as defendant merely shared or questioned publicly available information. If plaintiff is suing defendant for reposting another individual's allegations, then plaintiff must also sue the original poster. Bruh. Truth is absolute defense to defamation. Plaintiff has multiple businesses that have been dissolved. This is the verifiable fact supported by public records. Defendant's statements about plaintiff's tax businesses were based on publicly available documentation showing that her business was no longer a valid legal entity. Defendant's posting of plaintiff's contract with Vontrarius Funches regarding security services was factual and based on an actual contract. First Amendment protection. Defendant has a constitutional right to discuss public figures, businesses, and services. The TRO attempt to silence defendant's opinions and concerns is an unconstitutional restriction of free speech. Girl, Sherell is off. She has done her homework. I'm not even gonna lie. Plaintiff's business disparagement claims failed due to a lack of causation. Plaintiff has failed to prove that defendant's statement directly caused financial losses. Plaintiff must provide actual documentation evidence showing specific revenue loss linked directly to defendant's statements. Counterclaims. Boy, now she say, okay, since you want to do this, let me go ahead and put this back on you. Let me tell you what I want from you, Danny. Defendant reasserts the counterclaims previously filed, included but not limited to the following: defamation per se against plaintiff. Plaintiff has falsely accused defendant of criminal conduct, included but not limited to stalking, harassment, threats of bodily harm. Plaintiff made these statements with actual malice and reckless disregard for the truth, damaging defendant's reputation. Invasion of privacy, public disclosure of private facts. Plaintiff has publicly disclosed private, false, and misleading information about the defendant, which is harmful and not of public concern. Intentional infliction of emotional distress. Plaintiff's false allegations, TRO abuse, and defamatory statements were meant to harass and distress defendant. Violation of Texas revenge corn law. If plaintiff has shared, posted, or otherwise circulated intimate, private, or defamatory material related to defendant, this constitutes a violation of Texas law. Because y'all remember in the initial complaint, Danny actually posted some photos from, I believe that was Sherell's OnlyFans or some other site she got them off of, but she posted those. Um, so Sherell is asking for relief. She's asking the court to dismiss all claims against her with prejudice, meaning that Danny can never file against Sherell again. Deny all forms of relief sought by plaintiff, meaning don't grant her no temporary restraining order. Award defendant damages for defamation, invasion of privacy, and emotional distress. Order plaintiff to cease and desist from further defamatory statements and grant any further relief that the court deems just and proper. All right, Sherell, I see you, girl. And what is this? So this is a motion to stay proceedings. Let's see. Okay, so this is kind of like a how I want to say this. When you file a motion to stay, it's like you're putting a pause on it to allow for you to get what you need in order to prepare for a hearing or a trial. Okay. So Sherell is asking time to obtain necessary evidence, including official court transcripts, witness testimonies for the fair and just adjudication of this matter. In support of this motion, the counter plaintiff states the following. So she is the counter plaintiff because she filed her answer, but she countersued Danni. So let's see what she's saying. So, counterplaintiff is actively gathering crucial evidence, including the official transcript from the temporary restraining order hearing, which contains sworn testimony that contradicts the counter defendant, Danny's, current allegation. Sherell is also in the process of locating and securing key witnesses whose testimony is essential to defense and counterclaims in this case. And this is probably why CoreySSG spoke out about this. So she probably have been in contact with him to get him to be a key witness. She's asking for a temporary stay of proceedings, which is necessary to ensure that all relevant evidence is properly obtained and presented before the court to prevent undue prejudice against counter plaintiff. Because remember, she put out those subpoenas for Meta. It's going to take anywhere from 30 to 45 days. And that's the wait period that I usually give myself in order for them to fulfill that request and send that request back to you. And she's saying without, getting this additional time, it would be a very significant disadvantage as the inability to obtain those materials in a timely manner would impair the ability to properly prepare for trial and pretrial motions. And she stated the legal standards. Good. And she's saying that this is a good cause. She's not doing this just to delay this. She is doing it because she needs to adequately prepare for her pretrial motions as well as trial or any other hearings that they have. So this is very crucial to her case. So getting those official transcripts, locating the people that she needs to speak on her behalf, being able to get those subpoenas back from Meta, all of that is going to be crucial to her case. And she goes on to further say that the witness testimony is very crucial to prove the bad faith conduct and fraudulent claims that was made by Danny. Because without the testimonies, um, Sherell's ability to properly defend against those false allegations will be severely impaired. So she is asking for a hearing since this is a motion, and more than likely she will go up before the judge and pretty much explain everything that she stated in this, and just kind of um, persuade the judge to allow her to have more time. Um, she said a hearing will provide the court with an opportunity to hear additional context regarding outstanding subpoenas, missing evidence, and the necessity of certain witness testimonies. So she's asking to let's see, 90 days. So she's asking the court to give her 90 days to allow her to get all the necessary court records, witness statements, subpoena requests, everything, so that way she will be able to be prepared for trial. That's very outstanding. I like the way that she did that. You don't see a lot of pro se clients that are able to kind of hold themselves together and get everything done, especially when the other party has an attorney. And I actually had the opportunity to just do some document drafting for a couple of people, and to go up against people who have money and lawyers, and to get a call and say, hey, your documents that you filed and everything help me win my case. Like it's a awesome feeling. So Sherell is on the right path. She's doing good. I just hope that they are, allow her to build her case, because it does cost to get an attorney. It really does. So if you're able and you have time and you can do it pro se, all it takes is a little bit of reading. Just educate yourself, and you could take it from there. But y'all let me know what y'all think about the saga, man, because it's crazy. And I was like, okay, I do need to do an update on this because a lot of information has been left out since the last time that we spoke. But y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.